Hello, my name is Jason Colvin. I'm an attorney with Miller Johnson in the Family Law Practice Group, and I've been asked by the Education Law Group to put together one of the 5-minute messages to discuss some of the overlaps between family law and education law and questions that both they and I often hear from our clients regarding the same. First, I'd like to start with a general overview of custody. I think that's the main topic that we get asked about is what is custody, what does it mean, and what should I do about it? So in Michigan, custody is broken up into legal and physical custody. Legal custody really is major decision-making power. So for instance, if one parent had sole legal custody, they could change schools for the minor child without having to get permission or even notify the other parent. If it's joint legal custody, it actually requires agreement by both parties and both parents to change schools for the minor child. Now, how that relates to what the school should do, I would say not to change the policy. If you require a certain number of signatures of both parents or one parent to get transcripts, to move files, or to enroll a child, stick with that, unless you're made known that the situation is such that there's a joint legal custody situation and one parent is trying to change schools without the other's permission. Then I would say get both parents' signatures or get a court order or ask for a court order that says which school the minor child should go to, because there probably is one that exists. The other aspect of custody I want to talk about is physical custody. Physical custody is really just where the child resides. It's not the only place the child resides necessarily, but the primary place. In relationship to schools, it really doesn't carry any legal weight. It just means that the child is either with both parents, lives at both houses, or lives at one house primarily. That doesn't mean that that's the only house they're at. That doesn't mean that that's the only parent that may exercise parenting time or pick them up from school. Another main area that I get asked about is access to records. It's important for schools to know that there's a specific Michigan statute that requires them to allow equal access to children's records for school. So any school records that a parent normally would get, regardless of legal or physical custody, has to be provided to both parents upon request. The other thing that has to be provided is notification of meetings regarding the minor child with the school. So parent-teacher conferences need to be shared with both parents, even if one parent doesn't have legal custody. This is an issue in a lot of cases, and sometimes I see schools get this wrong where they say they've been told by one parent that they have sole legal custody, so they refuse to allow access to information to the other parent. That's technically not in accordance with Michigan law and something that school boards or schools should know about. The third area I kind of want to discuss is school pickup. This one can be difficult, and I think puts schools in a really bad position where they're supposed to make some kind of a decision regarding a court order. And that, frankly, is not the school's job and not something that I would recommend trying to do. The reality is, even if one parent has sole legal custody, the other parent may have parenting time. So they may be able to pick up the minor child from school. So you wouldn't want to deny a parent access to their child just because you have heard or see an order that says there's sole legal custody. You also wouldn't want to rely on an order that says there's joint physical custody to say that this parent, or sole physical custody, to say that this parent must be the only one that picks up the minor child from school. My recommendation regarding school pickups is to follow your policy regarding a access list or school transportation or pickup list. And if both parents are on that list, then allow both parents to pick them up. Even if one parent says it's not their parenting time, it's my parenting time. It's not really the school's responsibility, and they're not really in the best position to interpret a court order and say that only the dad or only the mom can pick up on any given day. If the child is there and there's someone there to pick them up that is allowed based on your own policy, then let them pick them up. If it's not their parenting time, let the courts kind of determine that and decide what to do next. Thank you for your time today. And if there's any further questions, please feel free to reach out to Miller Johnson for myself regarding family law or any of the education law attorneys, and we'll be happy to help.